I think we'll do a quick sound check. We have Justice Apple, who is participating on the Zoom. So we'll start with Mr. Kahler. Would you please check your system?
I think it's on.
Yes, I can hear you fine. Thank you, Counsel.
Thank you.
Yep, thank you, Justice Apple.
And it's the court's understanding that the two appellants will take turns with their arguments on both the initial as well as the reply. I believe you've been informed also you need to keep track of your own time other than the total time we'll keep track of. Okay, so would one of you, I think it's Mr. Hopkins who's going to go first. Would you like to give the sound check?
Can you hear me?
Yes, thank you, Counsel.
Thank you. And Mr. Hopkins, when you're ready, you may begin.
May it please the court, your honors, opposing counsel. My name is Brant Hopkins. I'm representing the Property Assessment Appeal Board here today. As the court is aware, we're going to try to split time, so I'll do my best to monitor that for you. This is a judicial review action flowing from a property tax assessment protest filed by Stateline Cooperative in 2014. It relates to a feed mill manufacturing facility it owns and operates in Emmett County. Stateline is claiming that a significant portion of that feed mill facility is exempt under a statutory exemption for machinery used in a manufacturing establishment. Case came before PAB. PAB found that, in fact, some portions of the property were machinery and should be exempt, but it also found that these bins, grain bins, as well as ingredient bins and load-out bins at the feed mill building were not machinery and should not be exempt. Went up to the Court of Appeals. The Court of Appeals disagreed and found that the bins, including the steel grain bins and the ingredient bins, were machinery and should be exempted. PAB sought further review for two main reasons. The first relates to the Court of Appeals' interpretation and application of the statutory exemption, and the other issue that we have concerns with relates to the method the Court of Appeals used to value the exemption for the ingredient bins. The Court of Appeals, in deciding this case, defined machinery by relying on non-Iowa case law and secondary sources that we believe modifies and changes the entire scope of the exemption in a way that isn't entirely consistent with the plain language of the statute. So we're asking you today to reject that interpretation. We believe that there are sufficient definitions already without resorting to outside case law to define machinery. We have common definitions, dictionary definitions. This court has relied upon those many times before. And we have, most notably, a definition from the Iowa Department of Revenue, specifically related to property taxation, that defines machinery. We believe those are enough definitions to work with. We don't need to resort to outside case law in order to define machinery. And on the issue of the application of the exemption, there's a couple things to keep in mind when applying the exemption. First of all, as this court has said many times before, it's the burden of the property owner, in this case Stateline, to prove it's entitled to the exemption.
Let me jump in. So talking about the ingredient bins, which is kind of the focus here since the Court of Appeals found that those were machinery, what is it, as far as those ingredient bins that are actually integrated into the manufacturing building, the ones that are kind of built into the building, what is it that makes them not machinery?
We have the testimony of Sherilyn Critchow here. She's the feed department manager for Stateline. She testified that there's no processing of the ingredients when they go into those ingredient bins. There's ample testimony that the ingredients actually move to those bins and are removed from those bins by the actions of other machines. We have the testimony of David Edge. He's Stateline's CFO. He testified that the exterior walls of the bins really are the exterior walls of the whole structure, and they protect the contents, as PAB found, from exterior elements, i.e. the weather, in much the same way that this building and us are being protected by the weather today, by its walls and its roof. So those are findings that PAB made. We do not believe the Court of Appeals gave appropriate deference to those findings. PAB found that the primary purpose of the bins is for storage, and
Is there anything in the record? I know on the corn silos, there's evidence in the record as how long the corn would generally stay there. But for the bins that are at the feed manufacturing building, is there anything in the record as how long the ingredients would stay in those bins before they would be used?
I don't remember offhand. I do recall the testimony about the length of time the corn remained in the grain bins, but I don't believe or don't recall there being testimony about the length of time the ingredients are in those bins. So, PAB made factual findings in regard to the primary purpose of the bins, and in our view, the Court of Appeals didn't give those findings the appropriate deference under the judicial review standards.
Aren't those findings binding on appeal if supported by substantial evidence, and the testimony you mentioned provides that support?
Yes, under the judicial review standards, those are binding if supported by substantial evidence, and as I just stated, I think that's the evidence which supports those findings. And ultimately, at the end of the day, if there are doubts about whether these items are, exempt, those have to be resolved in favor of taxation, and Stateline's burden ultimately to prove it's entitled to that exemption. The other issue, and I'm running a bit short on time, is the Court of Appeals method that they utilized in valuing the exemption for the grain bins. We do have concerns about that, as discussed in its order and in briefing. The methodology that Stateline's appraisers used to value that, in our view, is flawed.
Well, let me, and I'm going to take a little bit of your time here because I'm going
Okay.
to ask you a question about that. As I understand it, the PAB ruled that there was no showing that those of valuation for the bins, and therefore said even if they were machinery, the taxpayers are not going to get the benefit of an exemption for them. Court of Appeals, essentially, as I read it, adopted the property owner's expert's viewpoint and went through its own analysis and did its own calculation. Would it be fair to say that if we disagree that there's no value, if we say that's arbitrary and capricious, then what we ought to do is remand to PAB? We aren't the ones that should be making the valuation. Is that a fair assessment? If, assuming we conclude they're machinery, or some of them are machinery, but and also assuming we disagree with PAB that they have no value, wouldn't that be the appropriate remedy?
PAB is sympathetic to the Court of Appeals situation. We do feel like they felt it necessary to determine some value in order to apply the exemption. We just don't believe the correct way to do that is to ignore the agency's finding as to the reliability of that method. There is an issue of the burden of proof on this matter. If you get past that, then perhaps, yes, the correct remedy is to remand to PAB for additional factual findings about the value.
Because normally in an administrative review proceeding, we don't find the facts. If we find that the agency did it wrong, we send it back to them for a do-over. Isn't that right?
Right, and I'm sympathetic to the appraisers here. There hadn't been a judicial determination about what is or what is not exempt, so they did have a bit of a difficult task for them, but we do believe that at the end of the day that the valuation should be reliable, not only for Stateline's purposes, but for the other taxpayers in this county. With that, I'm going to cede the rest of my time.
Thank you. And if I could give a follow-up to your question, my name is Brett Wright. I'm here on behalf of the Emmett County Board of Review.
Mr. Ryan, could I get you to stay close to the mic?
I'm sorry.
Thank you.
I apologize. This matter was already remanded for the express purpose of showing the value of these components. The PAB looked at the evidence offered by Don Vasky, the expert for Stateline, and made a specific finding that he didn't provide credible evidence. So it's a failure of proof, and that's the end of your analysis. It's the PAB's findings on this were that Don Vasky did not provide reliable evidence of value. This was already remanded for just that purpose, to go back down to have them do that.
Counsel, so where did the assessed values of the components that were reduced by the Court of Appeals, where did those come from?
They came from the Iowa Real Property Appraisal Manual. And this takes me into one of the arguments that I do have that was not addressed by the PAB, and that is similar to the ingredient bins. Iowa law requires that there is a proof of value independent of the property that's been exempted. The best example, and I cite to it in my brief, is one that came from the PAB on a similar case like this. It's the Wendling Quarries case, where a taxpayer was saying the truck scales that were present at their establishment were exempt as equipment. It was a different statute, but same basic analysis. And these were, I don't know if you've ever seen a truck scale, but it is a poured pit foundation with the machinery inside. And the court said, yes, we agree that some of this is equipment that in this case was ordinarily moved upon relocation and is therefore not taxable because it's personal property. So you take that part out. But what you do have to show is what's the value of what you're removing versus the value of what's left. All that Stateline did in this case was essentially go to the property card that valued the property on a cost basis, and they removed components that they didn't like, or they allocated a percentage to it.
And isn't Stateline's argument here, though, that those numbers really weren't their numbers, and that the board should be stuck with those numbers?
That is their argument. It's contrary to Iowa law. If you look at the White cases, or the White case and the John Deere case, taxpayers have come in and said things like, I've tore that building down 3 years ago, simply remove that component of the assessment and I'm good. And this court said, no, you have to prove the value independent of that, because who's to say that other components are not undervalued? And I think this is an ideal situation to demonstrate that, because if you look at the actual cost of this facility, it was over $10 million. By the time we got it to the front door of the PAB, we were arguing, I think the total assessed value was about 4.5. So there's already a significant amount of equipment that had been not assessed. And if you're simply going off of the line items on the property card and challenging just this line item, oh, we like this one, just this line item, you're running that risk of, well, what if the other components are underassessed? If you allow a taxpayer to simply go in and pick and choose the bits and pieces of what makes up the total assessment, you'll be changing the law that's been around since the 50s. And two, you set it up so that you're fighting about, components, and you won't get to the meat of what is actually important, and that is, what's the value of this property overall? In terms of some things that we do think the court needs to take a look at, I don't think that the Court of Appeals applied the proper standard of review. Mr. Hopkins hit on that. There was a specific finding of fact for the primary use of these bins, and that primary use was that it was used to hold raw material and store it until it was needed in the manufacturing process, or it was used to store finished product awaiting shipment away. If you look at the regulation that defines what industrial real estate is, it says, industrial real estate includes land and building used for storage of raw materials or finished products and which are an integral part of the manufacturing establishment. I mean, either that regulation controls or the Court of Appeals decision controls, but those two things can't exist in the same universe. You have a situation where if the regulation means what it says, well, then you can't have the Court of Appeals ruling. It did not give the proper deference to the PAB's finding of facts on this. It's similar to the issue of the credibility determination for Don Vasquez's evidence of value. It is based upon substantial evidence, and they took it to a place where they essentially said, we look at this evidence and we find a different conclusion. That's a de novo review. That's not what they were supposed to do. And with that, I see my time is over.
Thank you, Mr. Ryan. Mr. Kahler?
Yes, thank you, Your Honor. Is it permissible if I take my mask off while I argue?
Yes.
All right, thank you. Good morning, Your Honors. May it please the court. My name is Brant Kahler, and I am honored to appear before you this morning on behalf of the appellants in this matter, Stateline Cooperative. If I could start by addressing Mr. Ryan's argument that somehow Stateline has an independent burden of proving the value of an exemption. That's simply not correct. PAB found that a component's assessed value is equivalent to its exempt value. The Court of Appeals held that as well, and both were correct in doing so. And it's important to remember, Your Honors, although there is case law that says that property is assessed and valued as a whole, if you look at the Iowa Real Property Appraisal Manual, the method of assessing a property like Stateline's is simply a matter of the assessor coming in and assessing a value to each individual component of the facility based on various factors such as age, size, type, et cetera. And then all of those individual component values are added together to get a total value of the property. There is no other, in addition to those component values, there is no other independent valuation of the property as a whole beyond those values. And so as a result, Your Honor, if you find a particular component or portion of the facility to be exempt, then the appropriate thing when you're assigning an exempt value to a particular component is to simply say the exempt value is equivalent to the assessed value. At the end of the day, Your Honor, it's really just like a math problem. You know, if you take 2 plus 3 equals 5, and for some reason you need to remove 3, you've got 2 left. The value of the property as a whole is not affected. And contrary to what Mr. Ryan was saying, there is case law that supports both PAB and the Court of Appeals in this regard. The Carlin Company Board of Review versus City of Clinton says that machinery is required to be assessed on an item-by-item basis. The Grundon Holding Corp case that we cited on our brief involved a building that was destroyed by a fire, after which this court simply removed the assessed value of that building from the overall assessment. And the Wendling Quarries Court case that Mr. Ryan talked about, what actually happened is the Court of Appeals found that PAB was incorrect, found that truck scale was in fact exempt, and then remanded it back down to PAB, who then entered an order of the value of that exemption that was equivalent to its assessed value. So,
That gets to the question I was asking the other side. It does strike me that even if you agree with the Court of Appeals on the legal analysis, wasn't it somewhat over-aggressive of the Court of Appeals to actually make its own valuation determination for the value of the ingredient bins? Shouldn't it have remanded to PAB to do that? If it said PAB used the wrong methodology and wrongly disregarded Vasquez's approach, shouldn't it still remand?
Your Honor, I think that's possible. However, if you look at the Iowa Administrative Procedures Act, specifically Iowa Code Section 17A.1910, once the Court of Appeals or this court here on further review, once it is determined that PAB acted arbitrarily or capriciously or violated the substantive rights of Stateline in another way under the statute, it specifically says that the appellate court shall reverse, modify, or grant other appropriate relief from the agency action. So I think that that statutory provision allowed the Court of Appeals to reverse as it did and modify as it did.
I'm
PAB's
just thinking,
determination.
let's say there's a workers' comp case, the commissioner says there's 0 industrial disability, the case comes up to us, the claimant's attorney said there was a 50% industrial disability, we conclude that 0 is wrong, that's arbitrary and capricious. We wouldn't then calculate the industrial disability, we'd send it back to the commissioner to recalculate it, wouldn't we?
In the work comp context, that may be the case, Justice Mansfield. I think the important distinction between this case and the hypothetical that you posed is, in this case, all the evidence in the record necessary for the Court of Appeals to modify PAB's decision was already there. So, like, for example, Your Honor, if you look at the grain bins in particular, our Stateline's expert, Don Vasky, when he was apportioning the assessment of the grain bin between the walls and foundation, the walls and roof and the concrete floor and foundation, he found that from a cost of construction standpoint, that 75% should be allocated to the walls and roof and 25% should be allocated to the foundation and floors. And after hearing that evidence, PAB said, actually, we think based upon our experience that allocation is really more a 70-30 allocation than a 75-25. So,
Can I return back to the issue of remand?
yes.
And can you address, I believe, Mr. Ryan's argument that this was already remanded for the purpose of finding or getting evidence on valuation, and that if we conclude it was wrong, this is just a failure of proof problem, and that Stateline already had 2 bites at the apple, and remand shouldn't happen here for that reason?
Respectfully, Your Honor, Stateline did not have 2 bites at the apple. When the hearing was initially held before PAB, Stateline's argument was that the entirety of the grain bins and that the entirety of the feed mill building were exempt from taxation. And then PAB ruled that we don't think that the entirety of any of those structures are exempt, but certain components of them might be, but there's no evidence of value in the record, so our hands are tied. So at that point in time, it went up on judicial review, and on behalf of Stateline, I asked the district court judge to remand the matter back down to PAB for additional findings on the particular exempt values of the various component parts of the structures that might be exempt. But even at that point in time, Your Honor, we didn't know ultimately what component parts were going to be found to be exempt. But what we did was, when we went back down to PAB on remand, we did put that evidence forward. And I don't think at the end of the day that it is a matter of failure of proof, Your Honor. I think at the end of the day, Stateline put forth all of the evidence necessary in the record to make the determination. And as I was telling Justice Mansfield, at the end of the day, PAB disagreed with the methodology that Stateline's expert used.
It just strikes me, I mean, there wasn't any question, was there, that these overhead bins in the feed mill cost something like $1 million to put in, and they were brand new. And if they're exempt, that exemption is going to have some value. And to say, well, we disagree with what Vasky said they were worth, therefore we're going to give it 0, that seems arbitrary to me. That's my concern. Am I missing something? I mean, maybe it's less than Vasky says, but it's not 0.
Right. Justice Mansfield, you are absolutely correct in that regard. So what happened was our expert, the overhead bins are part of the larger feed mill building. And all of the above grade space, so anything above the ground in that building, was all assessed together. There was never an individual assessment done of the overhead bins themselves separate and apart from the above-grade space of the rest of the building. So what Mr. Vasky did was he took the entire value of the above-grade space of that building, and he broke it down into the portion of the square feet that the overhead bins occupy, and used the same cost per square foot that the county used in assessing those bins, and then came up with a value. And importantly, he also looked at the construction documents in the case and determined that his assessed value of roughly $1,092,000 was within 6% of the cost to construct these bins as well, which was roughly $1,032,000. So from there, Your Honors, you're right. It was arbitrary and capricious, just like the Court of Appeals held, for PAB to simply say, we would have done it a different way. So for that reason, you have failed to meet your burden. Instead, Your Honor, at the very, very least, Emmett County Board of Review had an expert witness as well, and his name was Mr. Ehlers. And he came in and he said, essentially what PAB ultimately concluded was that all of the above grade space, including the overhead bins, is not of an equal value. So despite the fact that that's how it was assessed, if you were going to value just the overhead bins, those are more valuable on a per cubic foot basis than the rest of the space. So he used a different calculation, and he came up with an overall value for the overhead bins of roughly $778,000. So at the very least, while I think the Court of Appeals was correct in finding that PAB was wrong in dismissing Mr. Vasky's valuation method, at the very least, there was evidence in the record.
Counsel, there's an argument being made here that the standard of review that the court engaged in wasn't correct, and that they've essentially changed the definitions here from what we'd previously had. Can you respond to those arguments?
Yes, Your Honor. I think that although ultimately valuation methodology and those types of matters are within the expertise of PAB, and it's something that would usually be entitled to deference, you can't start there. Where you have to start is the fact that PAB was taking the machinery used in manufacturing establishments exemption language, it was interpreting it in a certain way, and then based on its interpretation, it was applying whether or not certain pieces of machinery were exempt, were not exempt, and then valuing them. But importantly, PAB's not entitled to any deference at all in its interpretation of the machinery used in manufacturing establishments exemption. And the Court of Appeals found that PAB incorrectly interpreted that exemption. And from that standpoint, PAB's not entitled to any deference in its interpretation of the exemption. And as a result, when PAB was using the wrong legal standard to then apply it to the facts of the case, it's hard to simply say that PAB's fact-finding and its application are entitled to a substantial evidence review or a deferential set of review when it started with the wrong legal interpretation to begin with.
All right, getting to that issue about, what's machinery, I know that, I think it was Judge Mullins for the Court of Appeals said, we can't apply I know it when I see it, but let me try and apply that.
Okay.
I mean, it strikes me that looking at the photo, those two things just look like, ordinary corn bins, corn silos. I have trouble seeing them as machinery. Why are they machinery?
It's funny you phrase it that way, Justice Mansfield, because what I've been saying throughout this entire case is these are not ordinary grain bins. These aren't the grain bins that are on your uncle's farm. These aren't the grain bins at your local grain elevator. Those grain bins take corn in or other grain and store that corn or other grain until it's time to sell them. That's it. That's their sole function. These grain bins in this matter are constantly flowing and a fully integrated part of the feed manufacturing process. As a matter of fact, corn is not directly added to, nor can it be directly taken out of these grain bins in any way. What happens is a semi-truck pulls in, dumps corn below the truck into a big open hopper that is then taken through a conveyor belt up, dropped down into the top of the bins. And then the fans and dryers inside the bins are constantly pulling the corn inside the bins down. And then once it gets to the bottom, there's a power sweep that's moving around that pushes corn into a hole in the center of the bins that is then reclaimed and taken throughout the rest of the feed process. And there is corn moving in and out of these bins 24 hours a day, 7 days a week. And somebody made a reference to this earlier, but there's evidence in the record that a grain of corn, kernel of corn, sorry, will only last roughly 16 days in the larger bin and only 4 to 5 days in a smaller. So from that standpoint, Justice Mansfield, despite the fact that it looks like an ordinary grain bin from the outside, it certainly is anything but that for the purposes of this facility.
You're talking about buildings 5 and 6 now?
Yes, Your Honor.
There was, I think, a footnote, some question about whether there was actually a floor sweep in one of the buildings.
Yep, so the smaller grain bin is the older one, which is building 6. There is not a power sweep in that grain bin. It was moved out, but it still has the same air fans and dryers that pull the corn down, just like in the larger grain bin.
What are the ramifications of our decision today? How many facilities like this exist around the state, if you know?
You know, Justice Waterman, I don't know the answer to that off the top of my head, but I would say any ramifications that come about are the direct result of the legislation in this case. I mean, interestingly, this machinery used in manufacturing establishments portion of the code was originally enacted as something that was taxed. It was specifically line item as something that was taxed as real property. And then in 1995, the legislature came in and they enacted a different code section that said this machinery used in manufacturing establishments language, anything that falls under there is now expressly exempt from taxation. And the legislative history intent on that, the purpose was, as noted in this court's case in the Carlin opinion, that the intended purpose of the exemption was to promote economic development in the state of Iowa and to keep taxes on manufacturing machinery at a minimum. So even Justice Waterman, if there's a widespread reduction in the state's overall tax basis, that's something that the legislature needs to take up. If a change needs made, that's not something that this court should do here today. And I see that my time is up. If there are no other questions, thank you for your time this morning.
Thank you, Mr. Ryan. And Justice McDermott, I've been given a message that when you speak, we want to make sure your mic's on because the camera can't see you and they're not hearing you. Or yell. Thank you. You may begin.
All right, thank you, Your Honor. First, I think the thing that is I want to address is this idea that Don Vasquez, his opinion of value was rejected by the PAB. They made a credibility determination on a witness, and they didn't find him credible, and that's a finding of fact that is entitled to the same deference as any other finding of fact. And if you look at their ruling, they specifically said he didn't provide reliable evidence of value for the components in question. This is on the remand that we're talking about. He used a replacement cost new for the grain bin, I believe it's building 6, of $780,000, but was unaware that the actual cost was $1.25 million. And he lacked, quote, any information to explain why there was roughly a $500,000 difference. He didn't include any site preparation costs in his analysis, despite such costs being included in the assessment. The PAB specifically found that Vasquez's methodology of extrapolating a per unit value from the whole and applying that to a portion of the property does not necessarily result in an accurate value of that portion. And we do not believe that Vasquez's allocation method is an entirely reliable reflection of the value of the ingredient and loadout bins. As such, they concluded that, quote, we are not convinced that Vasquez's allocations accurately reflect the value of the subject property Stateline believes to be exempt. Now, that's a failure of proof. If I come in any other case and let's say I failed to prove damages, I try and fail, I don't provide reliable evidence, I don't get I agree, Stateline hasn't had 2 bites at this particular apple, but they've had one, and they don't get a second. This is a situation where they were sent back down with the express instruction to provide a value for these components. They tried, they had a failure of proof. The PAB made a factual finding that their failure of proof was due to Mr. Vasquez not providing reliable evidence. That's the end of your analysis. In terms of the Wendling case, well, what happened with the Wendling case is this court recognized that there was a component of this truck scale that was taxable and a component that wasn't, and remanded it back down for the PAB to figure it out. Now, what happened at the PAB really doesn't matter, because whatever they came up with, the parties decided it wasn't worth fighting about anymore. But this court made a determination that part of this is taxable as real estate, part of it is equipment. Well, you have to show the value of each. Go back down and do that.
Can I shift gears a little
Certainly.
bit? I think it was Mr. Kahler talked about sort of the feed mill pulling grain out of the grain bins 24/7. Is the feed mill operating all the time? How often is it operating? What does the
It
record
is
show?
operating a significant amount of time, but it doesn't change the analysis of what this grain bin is doing is holding corn until it's time for it to enter the manufacturing process. And that is the regulatory definition of what is industrial real estate. I need to cede my time, and I'm sorry, Brad, I've gone long.
Thank you. I just want to touch on a couple issues regarding valuation here. Obviously, Stateline is of the opinion that it's offered, sufficient evidence to meet its burden. PAB disagrees. It doesn't believe it's obligated to rely upon evidence that it deems unreliable. Just to touch on specifically what the Court of Appeals did here, though, they, didn't find all of these overhead bins to be exempt. They said the loadout bins were not subject to the exemption, so the exemption only applied to the ingredient bins. Well, no appraiser has offered a valuation of only that section, which was valued by the Court of Appeals. In fact, I cannot discern how the Court of Appeals actually arrived at this cubic footage distinction that they've used to value the property. So again, we do think that there is a failure to recognize PAB's expertise on this issue. We don't believe the Court of Appeals has applied the correct standard of review. And to the larger issue of the exemption, we believe PAB correctly applied the definitions that exist for machinery, and we believe the order should be affirmed. Thank you for your time.
Thank you, Counselor. The case of Stateline Cooperative versus Iowa PAB and Emmett County Board of Review is hereby submitted, as well as Riley versus State of Iowa and State of Iowa versus Fettner. Court is hereby adjourned for the morning.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.